Good morning, everyone. I'm Rob Litz with USA&M, U.S. Arbitration and Mediation, and I'm so thrilled to welcome everyone today. This is our 82nd Best Practice Seminar. Could I ask everyone who's on with us to mute themselves so that just the speakers will be unmuted so we can all hear them and not cats and dogs and other assorted noises. Today is a terrific morning for three great programs. And before we get started with the first one, just a couple of housekeeping announcements. In the materials that were forwarded to you, the link that was forwarded to you by Kelly Spiller of our office, there are a couple important things. Number one, there is an evaluation form. It asks for how you thought about our programs today, but frankly, the most important thing we want to know is other ideas for future programs and future speakers. And based on the comments that we receive, we craft future programs in that regard. The Missouri CLE folks have provided a program ID number for this program. There is a certificate for Missouri credit. It's in that material. But if you want to jot down the program number, it's 693091, 693091. That's the number you can put in for your CLE credit. I mentioned Kelly, who forwarded that. I want to thank her. Judge Ott earlier had shared how she has been terrific to work with. She is always terrific to work with. She makes the trains run on time on all of our CLEs, gathering information, herding cats with our speakers sometimes, but she is fabulous, and I thank her for her great work. One other thing I'll mention to all of you, last year for the first time, we did a best practice program in June as a full day program for the first time. We're going to do another one of those on June 22. June 22, I believe it's a Wednesday. It's going to be a full day program. We're planning 8 or 9 sessions. We're going to have an ethics session. Alan Pratzel, the Chief Disciplinary Counsel, will be doing a program on ethics. We'll have a second ethics program dealing with diversity, inclusion, bias, etc., by CJ Larkin, one of our new mediators. Programs on arbitration, an interesting program on anchoring damages by plaintiffs and defense lawyers. So we're going to have a variety of things, and we look forward to seeing you at that program. Without further ado, I'm going to introduce Bud Whittles. Bud is a grizzled veteran of the USA&M panel for about a year now. He is a very experienced trial lawyer, graduate of WashU, undergrad and law, and joined our panel because of his broad experience representing plaintiffs and defendants. And we had kicked around some months ago a program, what's going on in various courts, and specifically in St. Louis County, because of the backlog of cases, both civil, family, associate, and circuit court. And Bud put the panel together with our judges, Judge Ott and Judge Medler. Bud, I'm going to let you do the intros and move forward. But I will also just mention there is an outline at the very beginning of the materials, and then we included some of the key local rules for the circuit court in St. Louis County. So things like the ADR rule, the family court rule that touches on mediation, and a few others such as pretrial conferences, et cetera. So that's in the materials for the attendees. Bud, thanks very much. Thank you, judges.
Thanks, Rob. So I do have the privilege of introducing our two panelists today. The first is Judge Mary Elizabeth Ott, who became a circuit judge in 2018, if I'm correct.
That's correct.
After serving as an associate judge since about 2008. More importantly, during COVID in September of 2021, Judge Ott was elected presiding judge of St. Louis County. and so is the presiding judge in St. Louis County. Also joining us today is Judge Jeffrey Medler, who I have known for quite some time in practice. Judge Medler is one of those judges who became a judge during COVID. He is an associate circuit judge in Division 37, took the bench in October 2020 during COVID, and has practiced as a judge only during COVID. And now that things are loosening up, maybe things will change. So I welcome both of you and thank both of you in advance for joining us today. I don't know if you want to address this or you want me to do it, either way. During COVID, there have been plenty of new faces in the courthouse that many of us have not yet met in person because we haven't been there for 2 years, give or take.
And we miss you.
And we miss being there.
Yeah.
I'm tired of looking at a TV screen.
Anything else, Rep?
That's a fact.
During the day. So if one of you would like, kind of give us a rundown on the new faces, the new judges, and the shuffling that has occurred during COVID.
Yeah. Well, thank you very much, Bud. And before we start this morning, I want to, and truly, I want to start by saying thank you. Thank you to, not only for having us here today, but thank you to all of the judges who exercised, in my view, tremendous patience and tremendous flexibility during the period of COVID, which I think we all know was, roughly speaking, March of 2020 until the present time. I think every practicing lawyer really had to be patient and flexible, and everyone was. And I know we are very, very grateful. So it's true that I became presiding judge in August of 2021. And before that, I was the assistant presiding judge to Mike Burton, who really did the heavy lifting during COVID. And the reason I'm not going to go through all of that, but I think to understand where we are now, it's helpful to understand where we started. And we started with directives and orders from the Supreme Court of Missouri, suggestions and advice, guidance really from the St. Louis County and the Missouri Departments of Health, and also the Centers for Disease Control. And what the Supreme Court directed us to do back in March of 2020 was to look at your protocols and procedures and adhere to things like the 6 feet distance requirement, masking, hand sanitizing, all of that, and then figure out a way to run your court given those parameters. And I am very proud to tell you that we did that in St. Louis County. I think you all know that. But it wasn't easy. It wasn't easy for practitioners, and it was not easy for the court. But I'm very proud, and particularly proud of our judges and of our IT department, who gave us the devices that we needed to work remotely. Anyway, it was a unique experience in the law. I don't know of any other time or group of lawyers and judges who faced those kind of circumstances. There certainly was no playbook for or precedent for how you handle it. And I am grateful to all of you. I think it went pretty well. So we never closed. And I want to emphasize that because I'm surprised how many folks in our state misunderstand that. We were limited during COVID, but we did never close. And that's a very proud point. But the very, very good news is because of the current conditions regarding COVID, and that is, and let me back up and say, part of what we did during COVID was set up our own monitoring system here in the courthouse. So we kept our own statistics on how many people were tested positive for COVID, how many people were exposed to another individual who tested positive for COVID. And we monitored our own quarantine. I mean, we did it consistently with the CDC and the Department of Health, but we kept our own records on that and did our own contact tracing. I think as a result of that, we had very low occurrences of COVID in our courthouse. One thing I'd like to point out, it's a little bit of an aside, but it's something that St. Louis County can be proud of, and that is there was an unflattering article in a journal written about prisons and jails in the state of Missouri during COVID, and how unprepared most of them were for it. And the one singular exception to that was the St. Louis County Jail. And so they had a very strict protocol, and they assisted us with setting up our protocol. And I'm grateful to them, and grateful again to all of you for complying with the requirements. So that's really what led to the backup, were these requirements, spatial requirements, and to have a trial, a jury trial in our courthouse during COVID required 3 courtrooms. So we were really restricted by space and time and what we could do, but we kept moving. Anyway, we'll get to that in a minute in more detail, but I wanted to make the point. So let's get back to now that we're opened up fully and lacking those limitations to the extent that we were required to adhere to them in the past. Who are the new folks? Who's here? Well, as you all know, Judge Virginia Lay was selected by the governor to serve in Division 16 of the Circuit Court, and she's handling a family court docket. Krista Payton was selected by the governor to serve in Division 41, and she is handling a civil associate docket. Heather Cunningham was selected by the governor to sit in Division 3, and she is handling a family court docket. There's a panel out right now for Judge Cunningham's spot in Division 33, and that is Megan Julian, our treatment court coordinator, Jason Denny, who's a prosecuting attorney, and Justin Ruth, who is a private practitioner here in St. Louis. So we are eagerly awaiting the governor's decision on that panel. We also, the Court en banc, at its last meeting, selected Jennifer Hoffman to serve as the juvenile court commissioner in Division 61. And that is as a result of the anticipated vacancy upon the retirement of Judge Diane Monahan. So those are the big changes, and they're all excellent changes. And so far, so good. So I don't think I forgot anyone on that, which is a good thing. All right, so let's go back to talking a little bit about the backlog and what the plan is going forward. We do have a backlog. There's no getting around that. And I think even the circuits who brag that they never closed also are experiencing some measure of backlog. But the good news is, I think, outweighs the difficulties in this. Number one, we have been able since last September, well, really earlier than that, but we're calling the regular number of jurors each week. So anywhere from 140 to 200 jurors are being called each week to sit for either civil or criminal trials. I am told by our jury commissioner, and I've checked with our judges, that as of today, we have not had to push aside or overlook a civil case as a result of jury panels being used up by criminal cases. So that is very, very good news. And I think in part that is because we kept, although in a limited manner, we kept the criminal docket rolling pretty well, excuse me, during COVID. We had a priority list, the speedy trials and things like that, that we kept moving. So I'm very happy to report that if you have a civil case ready to go, the chances are that you will be able to get a jury. We have some areas where the backup is far less. For example, family court is just about caught up. The criminal court is, depending on where you're looking, is not as backed up as we expected it to be. I think there is a backup in civil trials, and there is a tremendous backup in the traffic departments, and we are working on that diligently. We have added a third judge usually there are 2 associate judges assigned to the associate criminal divisions, and we've assigned for the last year a 3rd judge to help with that backlog. And that really is a good example of what we're doing. We're monitoring closely. How are we keeping up? Are we keeping up? And that's where all of you come in. If you find that there is an area where the backlog seems not to be being addressed, let me know. Let me know that, because we are monitoring that very closely. We have, by my statistics, 3 to 4 jury trials going each week. That's probably 1 or 2 more than average. And I think that's a good number. I think it will increase. I certainly hope so. I know that those are not really specific, but I can tell you that we are every week in close contact. Mr. Baumkamp, you're going to want to answer that. We're in close contact with the Department of Health. I talk to them weekly to make sure that, as the Supreme Court has directed, that we're monitoring the community conditions. Right now, masking is recommended but not required in the courthouse. And I think that's consistent with the current conditions. One thing I know, I had the occasion to be down in Jefferson City recently lobbying, and I had the sense that some of our colleagues in smaller circuits in the state of Missouri felt that we had closed our courthouse, which was never the case, and 2, felt that we had that the backlog was the result of that closure. Here's what I would say. I think every circuit in the state of Missouri worked extremely hard to do the right thing for their community and for the lawyers and the litigants. And as directed by the Supreme Court, each one of the circuits was required to look at population, the density of your population, the positivity rate of COVID in your community, in your building. So the fact that some circuits operated differently than St. Louis County, I think is the result of those conditions, not the result of really anything else. And I applaud everyone for paying very close attention to those details. But I think to the outside observer looking in and says, well, this county did it this way and you did it that way, that is the result of all of those conditions within the circuit and within the community. I wanted to talk to you about where are we going forward, all right? And we've had a great many, as you can imagine, discussions in our court about where do we go from here? What's the plan? During COVID, because of the 6 feet distancing requirement, we thought, and because of the fact that so much everything was remote, all right, and we had the equipment, we thought, wouldn't it be a good idea to have satellite courts in our community to reach out to people, to get them where they're living, and to not require them to have to come into the courthouse. So we thought, well, okay, where do we do that? So we looked at the statistics. Where do most of our litigants come from when they come to the courthouse? And hands down, it was North County. So that was an easy decision. Put the computers, put the remote equipment where the litigants are. And that was North County. And luckily, fortunately for all of us, St. Louis County government had a presence there at Northwest Crossing, and we put our remote proceedings there. But an interesting thing happened. They really weren't used very much. And we were surprised. People drove past that remote satellite procedure and came to the courthouse. And we were really kind of perplexed. So we started asking, why is that? Why is that happening? And the answer to me is kind of uplifting. The answer was that people respected the courthouse. They respected what happened in the courthouse, and they wanted their controversies determined at the courthouse. And even if that meant being in the lobby remotely, they felt more secure in doing that. And isn't that interesting? I mean, that was a surprise to us. but kind of a cool thing that people had such respect for the law and for what happens in this courthouse. And so I found that educational, interesting, and encouraging. And I hope that you look upon it the same way. However, another thing I wanted to say, there is no question when you are considering remote proceedings that it was a great advantage to a great many people. And we found this particularly in, and Jeff will talk about this, in the landlord-tenant area and in the family court area, where some of the proceedings were very short, and that by utilizing remote proceedings, individuals did not have to take an entire day off of work. They could step outside, maybe even at their workplace, have a 15, 20, 45-minute conference or hearing, and walk right back into work. We found that there was an increase in attendance at certain proceedings, particularly in family court and in the bulk dockets in associate civil. And so we, so as a result of all of that, however, that's the good side. So the downside of the remote proceedings, I don't have to tell all of you, okay, is, you're not there together. There's all kind of, nonverbal cues that are a little harder to pick up on Zoom. And there wasn't the serendipity that occurs when everybody's together in the room and things move much faster. I imagine most all of us, if we took a poll, would agree that you can get a lot more done, certainly from the judge's position, a lot more accomplished if everybody's there in the room. But understanding sort of both sides of that balance, we are not abandoning remote proceedings in any way. And we certainly found that there were all kinds of advantages to using them, but probably in a more limited way. And this is where I want to direct your attention to a couple of things. You all are well aware that it was in March of 2020 that the Supreme Court first entered their COVID orders. One of them, and this is the one I want to talk about now because I want you to consider this as you also consider what are you going to ask for to be remote. I have left it to judges and individual divisions to determine how they want to run their docket. We have individual dockets here in St. Louis County, and I'm allowing them to determine what will be remote and what will be required to be in person. But here's the difference. During COVID, the presumption was that the proceedings would be remote, and the requirements of the Department of Health, the Supreme Court required that. As of January 1st, the presumption now is in person. So if you are asking yourself, gee, I wonder if we're in person or remote, the presumption in St. Louis County is in person, unless you are directed otherwise by the judge. And now that's not necessarily case by case, all right? I anticipate that judges will have on their website what the situation is in their division. What matters will be handled in person and what matters will be handled remotely. Here's where I think the Supreme Court is going to draw the line, all right? My crystal ball not operating today, so you all will have to look at this and see what you believe the case to be. But as I say, March 25th, the Supreme Court entered their COVID orders, and one of them was the order to allow the remote administering of oaths, all right? And that was kind of a big deal because ordinarily it's difficult to find authority to do that, all right? So now here's the trick. In February of this year, the Supreme Court withdrew all of their COVID orders. So we didn't have any longer the order allowing for the administration of oaths. So I would invite all of you to look at a couple of things. I'm going to give you two citations now, a couple. Section 561.031 of the Revised Statutes of Missouri, 561.031. That sets out the criteria for remote appearances in criminal cases, all right? And it's limited, all right? It does not allow for remote proceedings in all cases, all right? So if you're thinking, hey, it'll be easier for everybody if we just do this criminal matter remotely, make sure that you and the court are in compliance with 561.031, all right? Now the question is, what about civil matters? Well, I would direct your attention to this case, CLF CLF versus KJR, and the citation is 618 Southwest 3rd, 618 Southwest 3rd, 632. And that's a Southern District case from 2020. And in that case, the court applied the provisions of 561031 to a guardian ad litem in a civil case. All right. So there's a little sort of like camel's nose under the tent there for breaking out of what is a criminal provision of 561031. Point here is there isn't clear authority for allowing a remote administration of an oath in a civil case, all right, but for this CLF case, all right, which seems to say, maybe we're starting to do that. Here's, after a lot of research, here's where I think the line is going to be drawn. But again, as I say, crystal ball not working. But my educated analysis is this. I think the Supreme Court will draw the line at whether or not testimony is being taken. So I think anyone is free to have a remote proceeding, criminal or civil, if there's no testimony, all right, i.e. not the requirement for the administration of the oath. One of the supports for that is an amendment that the Supreme Court has approved to Rule 55.30, and that will become effective July 1st, 2022. So just about a month or two from now. And that allows for teleconference in matters that do not require testimony. Boom, there it is, flat out, okay? So I think that's a good guide as to which way the Supreme Court may be leaning. And I think time will tell. And I think, there were two cases that went up from the juvenile court, one in which the remote proceedings were objected to, and that was reversed. And the other one where there was no objection, there was a waiver. There you are. So I think in all of these cases, I think the line is drawn as, do you have testimony or not in the proceeding? Is it just a scheduling conference or a hearing that isn't really, it's just argument? And whether or not it's criminal or civil, I think, of course, you'll have a little bit of a higher standard, and the confrontation of the clause of the Sixth Amendment involved if you're talking about the criminal matter. So all of that is by way of saying that, yes, we intend to use remote proceedings cautiously in the future, consistent with the law, which is not fully resolved right now. I think, because cases haven't percolated up to the top. I think there are a few, in the works. But I think we're in good shape. And as I say, I think, I hear from most lawyers that they are very pleased to be able to, have a scheduling conference where they don't have to, take an hour and a half for a 15-minute conference. So that's where we are as a matter of law. And I think I'm going to, if there are questions, I will take them as they come up, but I don't see any in the chat. Bud, do you have any? There's a lot of talking.
I don't have any in the chat, but I do have a question of my own.
Okay.
What do you and what does the court kind of envision, if anything, for the use of the satellite court in the future?
Well, here's where we are on that. Because it was so, and the numbers were really drastic. It was not even a close call. People were not using it for the remote proceedings. As I say, they drove by, came here to the courthouse and used the remote proceedings in the lobby. Okay. So, but what has succeeded in the satellite courts, and I'm talking, for my purposes, I'm talking about Northwest Crossing, all right, where the government has offices. What has succeeded there for over a long period of time has been the juvenile court. They have a presence there that has been successful over a course of years. And so we intend to expand and enlarge that presence and the services there. In fact, we intend to move some of the services offered here in the courthouse that are more appropriate for an out of courthouse setting. So, and that is something that the juvenile court has wanted to do for a long time. Now, I think that we will have for the foreseeable future remote, computers in the lobby of our courthouse to allow access to those people who do not have a computer at home. or do not have access to Wi-Fi or the internet at home. That they can, but if they come here, they can go upstairs and go into the courtroom. Okay, but there may be occasions where a computer is necessary, they don't have one. I think remote proceedings will be used for things like scheduling conferences, non-testimonial motions, and other things. I think there's an argument that can be made. I think Jeff will talk about this, about the efficiencies in the bulk dockets. So we will use them, and in the foreseeable future. Right now, I'm letting the judges decide in that sort of federal idea of laboratories of the state, laboratories of the divisions, and see what works best.
That being said, we could get Judge Medler's input as to the Associate Circuit Court, and perhaps even, and I am reluctant to correct any judge ever, but there are a couple other, I will clarify, a couple other additions that they've kind of been on the bench, it seems like forever, but they actually were appointed during COVID. So,
who did I miss?
well, you missed Judge Corrigan Jr., who I
That's
believe
right, and
was,
Judge Albus.
and Judge Albus, who
Right.
were appointed during COVID.
That's right.
And I think she goes by Pusateri Lassiter, was also appointed during the COVID period
All
of time.
right.
But they've been around, they seem like they're veterans and they've been around so long. One of the other changes that was made, I think just recently, was Judge Dotson was appointed as the administrative judge for the family court.
Yep.
Which will segue us into maybe Judge Medler talking about what's going to be happening in federal court. So Judge Medler?
Well, a couple quick things. One, it's not easy to talk about yourself, so I'll talk about Judge Ott for a moment, and then we'll move on to that. Judge Burton did do all the heavy lifting during the worst of COVID, but Judge Ott had the difficult job of transitioning to get us all back into court, and she has done a remarkably wonderful job getting us back in court. Right when she took over, that was her first plan of, if the numbers allow for it, how are we going to do it? And she has done it, and we have done everything in our power through town hall meetings, spreading the word and letting everybody know the courts are open. So the doors are open. We are fully open. Get to court is our position. When I got appointed, I kid you not, I walked the halls the first 6 months and never saw a lawyer. So I would literally walk around. I didn't see anybody. So I got to give Judge Ott an applause there, because she has done a wonderful job getting the word out and getting the doors open. So I wanted to start with that. As for the two things that I probably can speak on the most, one is Associate Civil. We are still currently hybrid. Most of the divisions are exclusively in person unless agreed otherwise with the court's permission. And I would say in that regard, talk to your judge. All of the judges are very approachable. My position globally is, if the two lawyers are coming in to tell me that we're doing discovery and we need more time, can we show up on WebEx? We can do that by WebEx. I truly believe we get more done in person. While you're out in the courtroom and the judges in chambers talking to other people, you all are talking and getting things done and talking about your case. So I err on the side of let's get everybody in. And I also think it brings back some of the camaraderie and the everybody get along. I have noticed during COVID that some of the communication, some of the doors of communication has been lapsed, I would say at best. I would say that lots of times you're getting people who say, we haven't talked to you since the last time we were on WebEx. And they didn't call me back. And I'd rather get everybody in, is what, at the end of the day, that's my position. But on the associate level, because we do have large bulk dockets, we still have summonses that have gone out that say hybrid, in person or by WebEx. So what the associate civil docket is doing is the hybrid, and the plan is by June 6th that we will be, the plan would be exclusively in person, barring any exceptions for the bulk dockets and the large numbers of cases that we have on the associate civil. So that's going to transition out. What I'm doing right now is for continuances. I'm asking that people show up in person, but the summonses that say show up by in person or WebEx, and I'm getting half and half. I'm getting 40, 50 people in person, and I'm getting 40 people on WebEx. And so it is really most difficult when I have one in person and one on WebEx. That's where I find things are problematic. And it's either the lawyer's on WebEx and the person showed up in person, which I really don't like, or the opposite where the lawyer is in person and the defendant is on WebEx. And then we did set up all of the kiosks on the second floor. So if people show up, we can get them on a computer and get them in breakout rooms and do things of that nature. So right now we're hybrid, and that is the plan going forward until these summonses work their way out. We expect that to be June 6th, to where that will then completely kind of wean itself off the system and will be exclusively in person unless the judge or the court and the parties agree otherwise. So that's where it is on associate civil. On the family court side, although I'm not in family court, I'm part of a sort of a workforce to try to keep family court moving. There was a backlog, and we do have some new judges that have gone into family. And so there was some backup when all that occurred. And I will tell you that there's two pieces of that. We're coming up with new ideas. We're meeting regularly to try to work on the family side of things. The judges want you in person. The judges want everybody in person. Judge Julie Lasker said to me on her first week of everybody in person, she got more done in a week than she did in 2 months of WebEx. So that should be a good tell that it works better in person. So the best answer on family is talk to the judge. And what I'm doing, and what I think all the family court judges are doing, your continuance memo will say in person or by WebEx. So if it doesn't say either, it's in person. As Judge Ott said, we err on in person. So if you're not sure, show up in person. Family courts, large docket is getting better, as Judge Ott said. However, we are brainstorming to come up with other ideas. We have two that are sort of in the works. One is something we're calling a pre-trial conference with non-hearing judge. It is mirrored somewhat off the Court of Appeal system, where you kind of, before you go and have oral arguments, you get a chance to go sit. I think it's Judge Gertner, I think, is doing it right now. If I'm correct, I think he's the one doing it, where you go and you spend some time. And we've got, I think, 4 judges that are not in family. That includes myself, Judge Gossity, Judge Zellweger, Judge, I think, Rich Stewart, and Judge Chris Kerr. I think there are 5 of us that if you have a family court case, you can take some time to go sit down with a non-domestic judge and with both lawyers and the parties. Usually we give 3 hours of, let's see what we can come up with. It is not going to slow the process down. It will not remove a trial date. It will not change anything. So if anyone has any ideas of trying to delay their game by asking for the pretrial conference with non-hearing judge, it won't work. That's not the plan. It's really just to get a judge's eyeballs on it, where you can talk a lot more open about the issues of the case. So that has started up recently, and we've already got some success going with that. Also, we are turning to a lot of our retired judges and some of our senior practitioners to do some special master work. So to the extent that any of you have any interest in any special master work, get to see your judges, go see your domestic judges, let them know you're interested. We are very much, especially for pretrial matters, PDLs and things of that nature. We're talking about trying to get some PDLs where a lot of the PDLs would go to a special master to be heard. So we've got a lot of ideas. Again, Judge Dotson just got in, and he came in flying. He came in wanting to make changes. He came in wanting to fix and not fix, but improve the system as much as possible. So he's got a lot of good ideas, and he's open for more ideas. So to the extent his door is always open, my door is always open. If you've got any ideas in that regard, whether or not it's mediation, special master, anything along those lines, our doors are open. So family law is going to get moving faster and is going to be moving. It has gotten better now that the doors are open, but we're still backed up a little bit. So I would highly recommend you do that. One other thing I wanted to point out, I did notice that Judge Preble is with us today. I want to give a shout out to him. I had a associate civil case and I ran into Judge Preble at a social event and I was complaining about the case should settle, but for that both lawyers wanted, $40,000, $50,000 in attorney's fees. And they wanted a jury trial over this. And that was, they both thought they were gonna win and get their attorney's fees. Neither one of them thought mediation would work, but neither one of them were necessarily opposed to me ordering it. And I ran into Judge Preble. I did not know that USA&M had a flat fee 3-hour type of program. And I would say to all of you, promote that, especially with the associate civil judges. I did send out an email to all of the judges and I told them about it because Judge Preble, to his credit, settled the case. And I really didn't think this was a case that I wanted 12 jurors to come in and argue about whose lawyer's pocket was going to get fatter. So Judge Preble did an excellent job, and I'm sure everyone else here, or some of you do that program as well. To the extent that you do it, and get your word out there, because I didn't know about it until Judge Preble said that. So if anyone is doing that, let us know, because I'd like to get more of these type of cases over to that 3-hour flat fee. That is an excellent program that we didn't know about. I did send the email, so the word has gotten out, but I think you need to talk about it more. So that's sort of where we are on family and associate civil. Obviously, if there's questions, great, but otherwise, Bud, let me know where we go from here.
All right, well,
Let me interrupt. Let
Okay.
me answer the questions that
Okay.
are on here. Ken Chackus, yes, I am very aware of the shortage of bailiffs for the remote area we initially called it the Zoom garden. We don't call it that anymore. But I am aware of that. And the problem that we are having in the sheriff's department and every other department of this courthouse is in recruitment and in hiring. And we are not unique in that. That is a national crisis, I guess you could call it, or certainly a situation. So we are aware of that. We asked and were granted by the county council additional funds in our last budget for additional bailiffs. And we juggled some around, but we are working on that weekly, if not daily. So thank you. And then we've had several comments about really the benefits of remote proceedings. And there is no question that there are benefits, and we all recognize that. And as I said before, we're trying to strike that balance between the efficiencies of having everyone in person and also the convenience that is afforded by the remote proceedings. And we're in the process of striking that balance right now. And I don't think anyone is looking for all in person or all remote, certainly not all remote. So yes, and thank you for your observations. I think there are some real, Jeff?
Yeah, I see that Jeff Wax made reference to showing up for one single case on a bulk docket. The one thing that I don't think a lot of people know, and I didn't know this because I didn't handle this docket in private practice. I wasn't here regularly. You absolutely can pre-announce. You can pre-announce, and we don't get enough of it. I have 140, 180 on a docket, and you're line 120, and you get to 120 and you say, can I have a continuance? If your case is under 180 days, you can contact the bulk filing clerks and you can tell them, I'm filing a continuance. What's your next rollover date? You don't need to come in and the same thing is for alias. I have lawyers that sit for an hour and a half, 2 hours to get their case. And then they just say alias or continuance. You can pre-announce those, and we appreciate it because then we don't have to call your case. So If you're waiting to see if it's a default, that's different. You got to wait for the docket. But if you can pre-announce it, it moves our docket a lot faster. So don't hesitate to find out who the docketing clerk is and get a hold of them and pre-announce or file a couple days in advance, and we'll take it off the docket.
Bud, I would like to tell everybody, I think most people probably know, my two neighbors down the hall, Judge Corrigan is currently doing a civil and criminal docket, and Judge Albus is doing the domestic violence docket right now. And Judge Lassiter, Julie Lassiter, is doing a family court docket right now. So that's the update on that. But you're right, they've been here forever. So I'll be hearing about that down there.
I want to be aware of the time, but I did want to touch, because before we went live, there was some discussion about incidents that we've all been part of that I would call professionalism or awareness. Since it sounds to me that remote appearances are going to continue, perhaps if you both would share just a little bit about your expectations about professionalism when appearing on remote.
Oh, please, can I
Yeah.
have that one?
Go ahead.
You're in court. You're in court. You're in court. It amazes me. Prior to going live, I told a couple of stories. Young lawyer showed up in a Mizzou hooded sweatshirt down by his pool. There's no excuse. No, you're down by your pool. Go inside, put a tie on. How about turn off your video? That's another one. If you're not dressed appropriately, but I really have been shocked. Prior to this, I made reference that I had to call a lawyer and tell them to stop appearing on my bulk docket in bed. We really need to remember you're in court, and it's not just the judges being snobby about it. That's not what it is. It's about representing the court. We all represent the system. We all represent the court. I would beg everyone, please put a tie on. And, get dressed like you're going to court. That's what you're doing. You're representing, and these lay people are seeing you and they're looking at you. And if you're dressed in a t-shirt and you're saying I'm an attorney, I must have said on bulk dockets, somebody says, Your Honor, I'm a lawyer. Can I get a continuance? And I usually say, I apologize. I didn't recognize you in the hooded sweatshirt. And it is not us being catty or any, it's just, you represent the court. And the other thing that I would say along those lines is, it is a presumption that the courts and all the judges believe is that you all have talked before you brought your arguments to us. And WebEx and virtual has brought that down quite a bit, where you're not seeing each other. Lots of times you show up in court for this case and you run into Bud on the other case and you say, hey, Bud, I know I owe you that discovery. I'm going to get it to you. That's one of the flaws of not being here. But we got to get back to professionalism, civility, talking to the other attorney, reaching out, try to work it out in advance. And then when you agree to disagree, I have an ongoing policy. If any lawyers have tried to work it out and they politely agreed to disagree and they don't want to file motions on this discovery, I'm available at least once or twice a week, informally by WebEx. They can pop on and we'll talk about your discovery problem. And I do that because as long as I know you all are working and trying, I'd be happy to try to see if I can keep moving along without waiting 3 weeks to get on a motion docket. So, Judge Ott, I'm sure you probably have some thoughts too, but.
Well, no, those are my thoughts. I think, and the idea about dress, to me, it's respect for what we're doing. And I think that, I don't know, I think I've always thought that attire was sort of an external expression of the inward respect for what you were doing. Now, if you have an impoverished client who comes in a sweatshirt, t-shirt, that's fine. That's fine. But I think underdressing for court gives off the wrong impression to others. It could be misinterpreted by others as a lack of respect. I don't think it usually is an actual lack of respect, but I think it can be interpreted by others in the public as a lack of respect. And I think that's, that's where you ought to give it some thought. And I would like to echo, my door is always open. I'm up on the 3rd floor. My courtroom is 381. And Carol Turner is my clerk, and I'm happy to hear from anyone at any time. I'm proud of what we've done. It hasn't been without hiccups for sure, and I'm sure that will be true going forward. But I think that we all worked together. I really do. I think the bench and the bar, it has a particularly strong relationship in this circuit, and I think it really shone through during COVID and currently, because we're not finished yet, but we're getting there. We're getting there. And on that, the Department of Health tells us that throughout all of this, that we have run about 2 weeks behind the East Coast, and in particular New York City. So they tell us that we can look for maybe a little bit of a spike in cases in the next couple of weeks. So so far so good here in the courthouse, but time will tell. But I am grateful to all of you, and I don't see any more questions. Bud, you got anything?
Don, I was going to say, I don't see any more questions, and we could probably continue the conversation for another
Forever.
hour, but I know that there's other matters on the program. So Rob, I will turn it back to you, and you can take it from there.
Super. Judge Ott, Judge Medler, and Bud, thank you all. This is an important conversation. I'll pick up on something that Judge Medler mentioned. Judge Preble and probably about 20 of us are part of a small claim flat fee mediation program. It's for cases where the last demand was $75,000 or less. Two-party cases primarily, and it's $450 per side. It's 2 hours of mediation. If you go over, it's $175 per party per hour. Substantially less than what we generally charge. We have a great team that do these. We have seen an uptick in those flat fee cases. And congratulations to Judge Preble in settling a tough one. Judge Medler.
Rob, would you send me an email summarizing all that?
Absolutely.
I'd like to get that both to the city judges and the county judges. I didn't know all those details, and I liked that program a lot. I knew just what Judge Preble and I had talked about, but you gave more detail. I'd like to have that, and I'd like to share it with the other judges.
And I'll certainly get that to you. And for the attendees on the Zoom, on our website, USAM.com, there is a tab under mediation, and under that, it'll talk about the flat fee program. And if you have questions, anyone certainly can call or email me. Great. Thank you all for this great program. Folks,
Thank
we
you
are
very
going
much.
to pause for about 7 minutes, and we'll have our next program starting at 10 o'clock. Thank you all.
Thank you, everyone.
Bye-bye.
Folks, welcome back. Our second program is a little bit different, and we thought it would be certainly of interest to the bar generally, and it's certainly an important area in the practice, and that's public interest law. And there's probably no one best in town talking about these issues and the folks at Arch City Defenders. Lee Camp and Jack Waldron are active daily working in this area. Lee has spoken on our behalf. I guess, Lee, it was last June at our all-day program talking about some landlord-tenant issues and part of the eviction crisis that was ongoing and still is ongoing. But we certainly appreciate having you here and presenting on this topic. They're going to go through a PowerPoint. A copy of that, folks, is in the materials that Kelly had sent to you. One administrative matter I would ask, there are a few folks who came logged in with just a first name or a telephone number, and Kelly has sent a chat message to each of you so that you could identify yourself for our record keeping and to be able to tell the CLE folks in Missouri, Illinois, if you're seeking credit along those lines. So if you could respond to the chat back to Kelly just to identify yourself so we can make sure you get CLE credit. So Lee, assuming are you going to lead off and you and Jack will go forward? Folks, if you have questions, put that in the chat and have it to everyone. And Lee and Jack will try to reach those questions as they go through. Folks, please go ahead. Thank you, Lee. Thank you, Jack.
Great. Thank you, Rob. Yeah, hello, everyone. Again, my name is Lee Camp. I'm an attorney with Arch City. I've been here about 5 years at this point and have spent the entirety of my legal career in the public interest space. And so Mike Geigerman actually called me and asked, if we could speak at this CLE. And it was an interesting opportunity because we give a lot of presentations in the community about the work that we do or who we are, but not so much geared specifically on the legal work that we do. And so today we're going to try to hit all those things and kind of give you an overview of who we are, but also the legal work that we engage in, some of the kind of key laws that we use and some of the roadblocks that we run into and the limitations of the law as it applies to our clients. We'll talk a little bit about kind of the barriers that are faced by our clients and how that changes the way that we have to actually engage as practitioners with different community members and clients that we serve, and then let you know the different ways that you can kind of plug into our work here at Arch City. So to keep us moving along, an introduction, who are we? You may have heard our name, you may know a lot about us, you may know nothing about us. We are a holistic legal advocacy organization that works to combat the criminalization of poverty and state violence, particularly in communities of color. We are a 501c3 nonprofit. We provide pro bono legal services at every level of the Missouri courts and in federal court, whether those are municipal courts, to the Missouri Supreme Court, to the federal courts and the 8th Circuit, et cetera. We don't charge our clients for this, and we do this with a goal of making a St. Louis region that's more equitable and that inspires justice for everyone. Our legal tools that we kind of use to do that work are really in 2 buckets. The first is direct legal representation, which we'll dig into today. A little bit more of your traditional type public defense work. And then our impact civil litigation work, our 1983 litigation, our large class action litigation that we engage in, again, on behalf of community members. And then because this is a CLE, we're going to spend the bulk of our time there today. But we do also engage in pretty extensive media advocacy. We engage in policy advocacy from time to time, working with low-income individuals, working, directly in issues of systems and racism. We have become subject matter experts in a lot of different things, and we get asked for our advice on different policies and things like that. So that is kind of another pillar of our work. And then we have a full community collaborations arm here, which works in partnership with different nonprofits around Missouri and St. Louis and really around the country. It works with grassroots organizers and people on the ground, moving from policy propositions and changes and movements really from the ground up. But again, today we're going to focus primarily on our legal representation. So how did we get here to where we are now? We're a fairly young organization. We were founded in 2009, again, as a holistic legal advocacy organization. And we'll talk about that holistic side in a moment. But when we initially started, the idea was that there was a gap between a traditional legal aid organization and a traditional public defender. And what that looks like is there are people that fall outside of both of those organizations for financial reasons, or maybe it's immigration status that prevents you from getting access to those services, et cetera. Or in the case of the public defender, there's been a lot of litigation over who gets public defenders in Missouri over the years. And so there was certainly a gap. And the initial intention was to cover that gap with our organization. And as we began to step into that kind of role and listen to our clients' experiences, we learned from them and we expanded our work to realize we could do defense work in small affirmative work day in and day out. But until we really start to go upstream, we can't make the kind of lasting change that we would like to see here. And it's what our clients were really craving. We're asking for us to do something to change the system, not just bail them out of their individual situations when they presented a problem. And so we started to transition into doing that civil rights work that Jack's really going to talk about later today. And after we did that, we expanded again, adding social workers to our organization, building community collaboration staff out. Our clients' problems are not simply legal problems. They encounter a lot of just day-to-day obstacles, and having on staff support like social workers really helps us achieve what we define as holistic legal advocacy. And now we've began expanding our reach outside of the St. Louis area. Within the past 2 years, we've engaged in what is kind of traditional Arch City work over jail conditions and exploitative practices related to the criminal legal system. We have litigated cases in Western Missouri in federal court there. We're currently litigating cases in St. Francis County, which is south of the St. Louis region. So we're starting our slow kind of expansion across the state to broaden where our work actually goes. And how do we do it? Well, this chart is essentially to show kind of the theory that we operate under. And that is, there are systems in place. If you start at the left side here, there are systems in place, of poverty and racism and inadequate social infrastructure that really perpetuate a divide in our community. And particularly these disparities are felt hardest in poor communities of color. And so where we lay as the legal team here in kind of envisioning this change, which is breaking down of these systems and really having a public space that is more safe and more well enjoyed by everyone living here, regardless of your race, regardless of your income, where Jack and I sat and our teams kind of sat is here in the middle in the pillars of our advocacy. And so we've mentioned this holistic kind of practice a few times today, and I'm going to actually ask Jack to chime in here as well. Our work starts with approaching it in a holistic way, meaning we will work on every legal issue. In my opinion, it means that we work on every legal issue that a client comes to us with. We can engage in criminal representation and civil representation at the same time. Again, a restriction that a public defender would have from engaging in civil, or a legal aid attorney would have from engaging in criminal work. So that is a uniqueness to our organization. We not only work to resolve all of those legal matters, as I mentioned, we work to navigate finding housing for someone that's living on the street at this point, or to work to secure someone's benefits in a way where they may not need an attorney, but may just need that kind of navigation and social work services. We offer all of that when our clients come in the door. And to me, that's what it looks like to be a holistic attorney and advocate here. But I'd be interested, Jack, what are your thoughts on that? Because we talk about this a lot at the office.
Yeah. So one example I like to use is one of our clients who we first met when he was incarcerated at the city's jail just north of downtown called the Workhouse. And he was locked up on a charge that he didn't think he was good for. We were able to help find him bond money, and so he was able to bond out. We were able to connect him with resources. So the only reason he was in jail is because he didn't have money to afford his bond. And he not only became one of our plaintiffs in the lawsuit against the city for the conditions of that jail, but we helped represent him in this tangle of municipal court and traffic cases that I'll talk about in a little bit. He started, when he came to us, his license was suspended. He had 7 different tickets that were outstanding from different municipalities. We were able to get each of those resolved because none of them were significant issues. They were all like his car was out of registration. And we were able to help connect him with social work and to job experience. So right now, today it's five years after we first met him. He's working, he's living with his family. He does not get more tickets because his car is up to date. And it's an example of where if we're able to sort of work with somebody in a lot of different facets, we really see that we're able to make their lives better. And that's what we found to be the most effective.
Yeah, and I think to that point, it differentiates us too from other organizations that look kind of like ours around the country, is that ability to truly attempt to resolve everything for a client. And so let's talk now about what that representation looks like. So I am actually a staff attorney in our direct legal representation group. Primarily 90% of my practice is going to be in the housing and homelessness space, where I work with families facing housing precarity issues or physically unhoused at this moment. But it goes well beyond that. I want to give an overview of that work and some of the legal tools that we use to represent our clients every day. Again, we work to integrate civil and criminal legal representation to kind of alleviate these collateral consequences that can happen when someone enters the legal system. What that looks like is pro bono representation in criminal, civil, and then very unique to Arch City, we provide pro bono municipal court representation, which may sound strange, as you know, at times we think about the municipal courts as kind of being the very lowest level of the Missouri court system, akin to like a small claims court on the civil side. But what we have learned is that actually this is where the rubber meets the road for most individuals. They never see a circuit court room. They see these municipal courts in cities and their, you know, school gyms or in their city halls. And really those courts can have very devastating consequences due to their somewhat punitive nature. And so we provide representation there as well. For our criminal representation, we work to supplement and not duplicate anyone's work. So public defenders, obviously, if you're charged with a crime, generally the rule is under Gideon, you're going to receive a public defender to represent you in that criminal case. However, as with anything in the law, there's not a lot of black and white. And of course, getting a public defender can be difficult at times. If you're charged with a misdemeanor, you're likely going to have to wait longer to get a public defender than someone that's charged with a high-level felony. There are obviously wait times associated with this. And there has been, I mentioned earlier, a real slew of litigation in the state of Missouri over the way the Missouri State Public Defender's Office operates. Some of it is almost friendly type litigation to show that our public defender as a statewide entity is underfunded and under-resourced. And with that being the case, we know that certain defendants set in jail, unable to pay essentially for their freedom through a bond, and can't get a public defender appointed to do those new bond revocation hearings or to try to reduce the bonds. And so at times we will supplement that work and step into those situations when contacted by the public defender. And then when jail time is taken off the table by a prosecuting attorney, this could also impact your ability to get a public defender. That might be a situation that we come into the picture as well. A lot of our criminal representation is focused on areas that we do have expertise. Some of that you will see reflected in the civil rights work that we do. So working with unhoused residents, which present unique problems, no addresses, have to find them, similar charges usually for those individuals. We represent a lot of individuals in protest cases or First Amendment defense cases, and then individuals, again, that fall outside of the qualifications for a public defender. Some of those cases are trespass and victimless misdemeanor charges, unlawful assemblies, failure to comply. And then we also have an expungement program here where we work with individuals to expunge their criminal and arrest records as part of this kind of holistic approach to resolving everything that someone has that is a result of their interaction with the legal system. On the civil representation, oh, sorry, Rob.
Yeah, Lee, there was a question. Obviously, there is a tremendous need both on the civil and criminal side. Is there a particular criteria that your office uses to decide whether to take a particular clients matter? And then what are those criteria?
Sure. There are not, again, like some entities that have kind of financial restrictions and whatnot. We do not have those restrictions. And in fact, over the years, we've moved away from even funding sources that require that we have a rigid guidelines on who we can work with. I liken us to being an open funnel. We will help individuals, no matter how they contact us, whether that's a Facebook message or a formal application or a phone call. If we have capacity to help and it falls within an area that we do have some expertise, we generally will do our best to help in that moment. While that sounds fantastic, it's not a lie that 9 out of every 10 people that contact us, we likely have to turn away for those very capacity reasons. Almost always our attorneys work at a maximum kind of output level. There's never a moment of pause around here. And there's also a lot of flexibility that we keep to be able to kind of jump to emergency issues, which I may talk about one that's popped up for me even this morning. And so we don't have restrictions on things, but generally do try to work an individual representation kind of within these parameters that we're talking about right now. And then in the civil rights work, I'll let Jack kind of talk about that. We have a few focus areas where we do have expertise, and right now that's where we're taking cases.
Great, thank you.
Yeah. So on the civil direct representation side, this is where I spend a lot of my time, is in the housing and consumer work. So that can look like eviction defense or subsidized housing grievances, responding to illegal lockouts, families that show up to their home after their day at work and they find that the doors have been, the locks have been changed or physically boarded up out of their home. Sometimes even we get involved in municipal practices when a home gets condemned and have to appeal those processes with the city for renters primarily, but sometimes homeowners there. My particular specialty is in access to safe and sanitary housing, ensuring that there's no kind of predatory behavior around that balance of a landlord and a tenant under Missouri law, particularly related to conditions issues and just the general management of rental housing, and then unlawful debt collection practices. So somewhat akin to a traditional consumer practice, but very much heavily focused in helping renters because we have had such a tremendous outpour of requests for those services. To your very question, Rob, how do we pick who we help? We generally look at where the requests are coming in, and housing for the past 3 to 5 years has just been a very high needs area in our community. And so we've recalibrated there and brought staff on to work in these issues. We also do some family law, some public benefits work, and then just various other civil kind of cases as we have the capacity or have the experience on staff to help with. And so I'll talk about the legal approach that I use in a lot of my cases. In housing cases and consumer cases, I frequently rely on traditional consumer remedies like the Missouri Merchandising Practices Act in Chapter 407. That is our state's Unlawful and Deceptive Practices Act. It allows for actual damages to be issued, punitive damages, attorney's fees to be issued, in conjunction with the sale of a good. For us, a lot of that is rental housing, although it could be related to lending practices, et cetera, exploitative payday lending, that type stuff. Generally, I'm working in the housing space using this law, a lot of common law torts, negligence, emotional distress, forcible entry, which is a specific statutory remedy for those type of illegal lockouts that we mentioned, abusive process and malicious prosecution claims, breach of contract, fraud, unjust enrichment. Again, things that you hear in a traditional consumer practice. We have a lot of that experience in-house. We also use appellate litigation as a tool fairly frequently in both our criminal and civil work. For a lot of the issues that we work in, again, the entities that work on those are traditional legal aid or traditional public defender entities that don't have capacity to maybe take the challenge on to the next level. And we will certainly embrace that and try to see a case through to its end, including using appellate litigation, especially in times where maybe the state legislature has passed laws that are not as friendly to our client population as the kind of adversary in these situations. We generally will try to attack some of those things through appellate litigation and then administrative kind of decision appeals that can lead to federal litigation or federal administrative agencies coming in and looking at cases. I wanted to use a case study here before I kick it over to Jack to show what this looks like holistically on the direct representation side. So I'm going to talk about my clients, Obadiah and Chantel. In 2017, we received calls from several individuals that lived in an unlicensed boarding home in North St. Louis City. And we went over and we met with those individuals and looked at the conditions in the property, of course, discovered that it was unlicensed, noticed a litany of different habitability issues, including a ceiling that was collapsing in the kitchen, the shared kitchen of this home, a real safety hazard to these individuals. And they had stopped paying their rent and were concerned that by stopping paying their rent, that their landlord was going to take a nefarious activity against them. Well, they were really in a rock and a hard place, couldn't move due to financial limitations. So they needed this roof over their head, regardless of the condition that it was in. And of course, their fears did prove to be sound. Their landlord came over to their home, literally put this board over the door with star bolts in it, so they couldn't even take it off with a normal screwdriver. We immediately got involved in this case on behalf of our clients and their son, secured a temporary restraining order and then an injunction against the landlord, a preliminary injunction against the landlord for violating the due process of law that must be afforded before you evict someone in Missouri. Of course, that didn't really stop the case. The landlord then goes to court, files a separate action to evict the family. There we get involved and we countersued at that point on behalf of our family. They had lost a lot of property. They certainly had dealt with emotional distress issues related to this, were displaced from their home temporarily. Regardless of the counterclaims that were filed, regardless of the preliminary injunction that was pending against the landlord, he violated that and locked our clients out again. During the course of this representation, we secured a contempt order against him. We got a major judgment of over 6 figures for our client, over $500,000 for our clients in actual and punitive damages and attorney's fees. And then, while that's great that we've won the legal case and resolved that situation, what they ultimately needed more than money was a way to get immediate housing stability while we attempt to collect on those judgments. And so we were able to eventually secure a housing choice voucher for this family, a Section 8 voucher, and they've been stably housed now in the future through our social work program, where the social work element comes in. I think this is illustrative of just generally all of the different areas that we have to be working in to help just 2 people kind of get out of their mess at that point. And that involves going into courts of equity, traditional civil courts, doing very traditional civil litigation, and sometimes not, to meet the needs of our clients. In the municipal representation space here, we work on moving and non-moving violations, ordinance violations that are misdemeanor equivalents. So assault charges, possession, shoplifting, trespass. These can be issued either by a state prosecutor, the circuit attorney, or by municipal courts. And these municipal cases are interesting in that they're not subject to Gideon unless jail time is on the table. It's something that frequently isn't on the table in municipal court. So there's no right to counsel. And as much as we try to become experts and understand the inner workings of municipal courts throughout our region, I believe there's still nearly 90 municipalities in the St. Louis area. I'm sure Jack knows that exact number. And most of these municipalities have individual courts with different procedures that are somewhat impossible for us to navigate as, learned attorneys that practice in this stuff every day, much less the general public to go in and try to avail themselves of the due process they're entitled to under the Constitution in these courts. So, we have fit a need there of providing free legal representation in the municipal courts since our inception now, since 2009. And really have, through this work, been able to expose some really grave injustice that occurs in these very low levels of the courts, and have had success there, and would like to think we have been instrumental in pushing for some of the reforms that have occurred in municipal courts, but also knowing there's a long way to go before we really see these as, true semblances of a courtroom in our region. How do we do that? We go in with our own toolbox on these cases. Municipal ordinance violations are quasi-civil and quasi-criminal. We very much push for these to be treated like criminal proceedings because they have punitive consequences to the families. We rely on being experts on Missouri Supreme Court Rule 37, which governs the municipal courts. I have a section over here that's quoted about inability to pay, essentially. We frequently go in and argue that fines and fees should be abated for our clients, and are doing that in a courtroom where multiple poor people are sitting and should have fines and fees abated, but can't get access to counsel. We use these rules in our representation to educate judges and to ensure they know that there are attorneys out there that are willing to view these practices and watch what's going on in these low-level courts. We resolve matters that are in warrant, or we resolve matters that disposition's already been entered. So someone pled on a traffic case or a shoplifting case years ago, but was never able to pay the fines and fees. We will actually get involved in the post-disposition stage, which is a little unique to try to clear up that matter and see that it no longer carries consequences for our clients. I mentioned abating fines and fees. Judge Ott just mentioned in the past presentation about the associate traffic dockets and criminal dockets. We frequently elevate our cases to that level, and we jury try municipal ordinance violations. We have had trials go for a week on municipal ordinance violations that I've been a part of. It is not something that we frequently see from the private bar, and that's okay, but certainly our clients are entitled to zealous representation even at these low levels of the courts, and we use every tool that we have to ensure that that's happening. One kind of last case study, just to explain again why we need this before I hand it over to Jack. If you think of driving from downtown to the airport, you're going to pass through about 20 different municipalities, north and south of I-70 there. And really the cascade can happen. If you're ticketed in one of those municipalities for a traffic violation, you have to check to make it to court. Technically, a case isn't issued when a ticket is issued, which a lot of people don't know. We run into inaccurate court dates being printed on traffic tickets and things like that for our clients. So we'll find out they're actually warrant because they've missed a court date, even though they've attempted to go to a municipal court that's either operational or maybe now inoperable, changing the days that they're operating on. Maybe they're in a hybrid setting due to COVID still. It could just get really tricky to kind of navigate that piece. If our clients go warrant, now they face their license actually being suspended. That can have devastating consequences for someone that needs to get to work, obviously, can trickle down into economic hardship that could lead to things like evictions that we continue to work in, and picking up tickets in other municipalities. This leads to the web that Jack mentioned, where 1 or 2 municipal court matters can quickly turn into 10. And you have to literally untangle these processes in concert with one another. And it takes a lot of skill and experience, and really just a lot of patience and navigation skills to get through those things. And a lot of our clients, express to us that would be very difficult to do on their own, and it absolutely is necessary that they have an attorney. So as I hand it over to Jack here, our direct representation that we've talked about today, this is really the foundation of or impact civil litigation. You know, eviction representation can lead to class actions against the property manager. Municipal court work, which we've historically done, has led to several debtors prison class action lawsuits and multiple successful ones here in our region. And then we, again, do direct representation of protesters, and that's informed the 1983 traditional civil rights work we do there. So at this point, I'm going to hand it over to Jack to talk about our civil litigation unit.
Great. And I saw, before I jump in to talk about sort of some of the civil litigation we do, I saw one of the questions said, where does ACD get its funding? As Lee alluded to, when we started off, basically the only place, we were so small, it was a couple of attorneys working part-time. The only way we were able to get money initially is from government grants to help certain populations of folks, whether it be elderly folks, whether it be homeless folks. And that has slowly transitioned into private grants and individual donations, as well as attorney's fees. One thing Lee mentioned that I want to touch on is that oftentimes many grants from the government require a lot of work on the back end, or require us to only serve a very narrow segment of the population. And so we've tried to transition away from that so that we can really help whoever it is that we want in whatever population we think is the most needy. So for instance, there aren't government grants that say help people get their traffic tickets in order and help people get their licenses back. That's not like a government need. And so it was a need, however, that we identified. And so, thankfully, we've been able to supplement our funding from other sources to help us out with that. And I think that it's a good transition. Lee, if you'd go to the next, I think 2 slides up, a good transition from the work that Lee's talking about for direct representation, because this photo is from the city of Ferguson's old municipal court from about 2013. And as much as I think lawyers like to complain about how hard our jobs are and how much the law can be difficult, I think we're shielded from the vast majority of how brutal the law can be, quite frankly. So to give you an example, this is a line out the door in the city of Ferguson Municipal Court. There are still lines out the door in municipal courts in the St. Louis region, despite the fact that there's been supposedly some reform. When lawyers go into the municipal courts, they don't have to wait in line. They don't have to wait in the cold or in the heat. They get to go along the side. Most of the times, we don't even have to go through security or anything like that. We just jump to the front of the line and get to talk to the judge. Meanwhile, most folks who are sitting in the back of the line are waiting 2 or 3 hours in order to talk to a judge. And the reason I bring that up is because the work that we did in the earlier part of last decade, when we were just starting, is this day-to-day municipal court work. So on a given night, we'd have attorneys going to Jennings, to Ferguson, to Florissant, helping out one client at a time, trying to get their license in order. And what we realized, of course, in the process of going into court is for every one client we're helping, we're walking past dozens, if not hundreds, of folks who are mostly poor, mostly African-American, who we aren't able to help. And so at a certain point, right around 2014, 2015, we started, in addition to this direct representation work, which we remain committed to, we started to file some specific litigation, mostly under the United States Code 42 USC 1983. So the statute is commonly called 1983, federal civil rights lawsuits against individual municipalities, individual officers, in order to try to get systemic change for these folks who are sitting in line, with the idea that the biggest way we're going to be able to make the most change is by trying to address these on a systemic level. So, Lee, could you go to the next slide? I think that most folks here, this is not a big secret. The North County of St. Louis specifically, if you go every few blocks, you'll find a new municipality. Each of these municipalities back in the day had their own court. Sometimes it'd be in the basement of City Hall. Sometimes it'd be in a little house. Sometimes it'd be in a gym. Each court had its own procedures, making it really impossible to navigate if you were somebody who didn't have a lawyer. And so, this slide shows, I think, 15 or 20 of these municipalities in North County. There are another 15 or 20. Many of these municipalities we have filed litigation against at one point or another. And what we've seen in the past few years is that some of these municipal courts have consolidated, although that certainly does not address all of the issues that we see. All right, Lee. So I want to talk about the law so for the vast majority of the cases we file them under 1983. It was enacted in 1871 as part of the Ku Klux Klan Act. And what the law basically does is try to answer the question, okay, somebody violated the rights that I have under the Constitution. What can I do about it? And what it gives is a right of action. So somebody violated your First Amendment rights. Somebody violated your 14th Amendment rights. You can, after this statute was enacted, you can sue somebody in order to get injunctive relief, in order to get damages, in order to get declaratory relief. And we use each of those different forms of relief in different ways. The statute provides remedies for people against any person who's acting under color of law. So a strictly private citizen, I couldn't bring a 1983 statute against. And under color of law is something that we spend a lot of time litigating. We represented a couple people about 5 years ago, 2 women who were drugged who alleged that they were drugged by a Pine Lawn police officer. And he was at the time off duty, he was in his police issued car. Much of that litigation had to do with whether or not it was under color of law, whether or not he was acting as an officer. And we see sort of wrinkles around that very frequently. All right, Lee. Lee, could you go to the next slide? Thanks. So we see that if under 1983, you've got to file, you've got to sue folks. If you want to get damages, you have to sue these officials in their individual capacity and not their official capacity. And the state is not a person. So while municipalities or cities are a person under Monell, the state that itself is not an entity that can be sued. And we'll talk, oftentimes what we do is we file these Monell lawsuits. And sometimes it can be on behalf of an individual plaintiff, sometimes it can be a class action. But what we're trying to do is address not only the actions of an individual police officer who we could sue under their individual capacity, but also the entire municipality for a pattern and practice of deliberate indifference related to a series of different potential constitutional violations. All right, Lee. So I want to, as the part of the sort of eat your vegetables part of the CLE, I thought it'd be worth going over some legal issues that we come across a lot that have to do with immunity, that have to do with who you can and can't sue in mostly in civil rights law. So if we just take the instance of a police officer who beats up one of our clients, we could file a 1983 lawsuit against that person asserting an unconstitutional seizure and for excessive force. So that would be a constitutional claim. But we could also file state claims against that person for assault and battery. And what we come across in state cases is that there is official immunity. So for state claims, if an officer is just doing discretionary acts, and if they're just doing their job, we often would come across the obstacle of official immunity. If it's an instance where there's excessive force used, you can get around that by showing that there was malice, that they acted out of their official duties. And that's one way to get around that first barrier of official immunity. All right. So judicial immunity is another issue that we come across. If a judge does something to violate somebody's constitutional rights, you are not able to sue that judge as a member or as a person underneath underneath 1983 and get damages. There are a variety of reasons for that we don't have time to get into today. There are a couple of exceptions to that. For one thing, if a judge would do something without any jurisdiction. So for instance, a judge doesn't have any jurisdiction over a person but seeks to exercise jurisdiction, that could be one exception to getting damages against the judge. Another thorny issue is issues of injunctive relief. In limited instances, a federal court could order injunctive changes to happen in a specific court, or could order a judge to do specific things, a lower municipal or county court judge to do specific things. But that's also a tricky issue because of some abstention things that we won't get into. So we've got official immunity, judicial immunity. Next slide, Lee. And then one that I think a lot of folks have heard about, and I think a ton of folks don't necessarily know a lot about it. It's called qualified immunity. The underlying case for qualified immunity is Harlow versus Fitzgerald. And one way of explaining it is that qualified immunity protects all but the plainly incompetent or those who knowingly violate the law. And what this immunity provides to often police officers, but also corrections officers or any government employees, is it provides immunity both from discovery itself, so at the motion to dismiss stage, but also from trial if they're able to show that they're entitled to it. We see it come up in a number of different ways, but the underlying idea is that you can't hold a governmental official liable, or excuse me, liable for a civil rights violation if that underlying violation was not clearly established. And that can be really tricky because oftentimes we argue, of course, it's clearly established that an officer couldn't hurt this person in this situation. An officer couldn't have taken these steps, even though that officer did. And then what the defense side relies upon is this idea that officers are reading or following the state of the law, and so they would know what has been clearly established as a constitutional violation and what has not. As you all can imagine, governmental employees are very busy people, and as far as I've been able to tell from having deposed many police officers, they don't spend a lot of time reviewing case law from the Eighth Circuit about what is and is not clearly established. Nevertheless, that is sort of a presumption on which qualified immunity relies. All right, Lee, next slide. So in order to overcome qualified immunity, you've got to address two big issues. The first one is you've got to show that there was a constitutional violation, right? That's pretty obvious. If you can't show that there was a constitutional violation, you're going to lose. And this would apply both at the motion to dismiss stage as well as at the summary judgment stage. And then the trickier part that I mentioned earlier was the constitutional right clearly established. And that's where things can get really difficult because, as you can imagine, oftentimes plaintiffs want to say broadly constitutional rights are clearly established, and defense attorneys are going to want to say in this situation, in this exact instance in which it was nighttime and a person was handcuffed, but the person was still moving around, and the defense attorney will want to try to pin it down as much as possible in order to say that this individual instance was not clearly established, and therefore that the officer is entitled to qualified immunity. One generous way of looking at it is this case, Ashcroft versus Al-Kid, which is whether every reasonable officer would know that the conduct was unconstitutional. Unfortunately, that reasonable officer standard is not used all the time. And there could be many instances in which I would love to argue, well, any reasonable officer would know this, but courts prefer to look at sort of a different standard about whether it was clearly established. All right, Lee. So to give some instances of where courts have found qualified immunity, a 14-year-old was held in pretrial solitary confinement for a month, and courts found, well, it wasn't clearly established for a corrections officer or for a jailer that, excuse me, courts have found it wasn't clearly established and therefore qualified immunity. In addition, we've seen a number of instances here, kicking a handcuffed man, including, should have brought my water with me, the last one, stealing $225,000 in cash when executing a warrant. A court found that it had not been clearly established that that was a constitutional violation, and therefore the officers got qualified immunity. All right, Lee. So Lee, I'll pass it back to you because I know.
I want to ask you one question, Jack. Just if you could speak to like a qualified immunity issue that we're seeing right now and having to deal with. Could you give an example of one that we're currently facing or have recently faced without, interfering with the litigation?
Sure. So one instance is that I had a client who was ticketed by an area municipality, and he was given 9 different tickets because basically he got into a discussion with the officer, and the officer our client alleges, retaliated by writing 9 different tickets. And so the municipality, and these tickets ended up having really grave consequences for this man's life. The municipality said not only did, excuse me, not only was there no constitutional violation, but also even if there was a constitutional violation, it was not clearly established that an officer could not write 9 accidental tickets, and therefore this person is entitled to qualified immunity. We're currently briefing that case. It's already been up to the 8th Circuit and back down once. But that's one instance, Lee, of where we see that pop up. There are a number of other instances that I think I even see some co-counsel here on the call who could probably chime in.
Yeah.
But for lack of time, we probably won't.
Yeah, I appreciate that. I think it's important. I mean, we see this every day. It's something that hits the headlines, but literally something we deal with. And you may not realize that there are attorneys working on these issues every day in St. Louis that can have national consequences too. We only have a few minutes left. I'm going to breeze through these in case there are any questions. You know, our clients have unique issues. I think that's probably no surprise to anyone that's ever been on the other side of a case with us or worked with our organization. There are transportation limitations. We've heard about that this morning, how remote court worked for some and not for others. And that's because our clients frequently live in the digital divide. This was much exacerbated in COVID when the schools and the libraries were closed, places that frequently our clients use as kind of technology access points. The myriad of extra legal issues facing them every day, trauma, substance use disorders, other mental health issues. And then they have reasons to be skeptical of attorneys just generally in this system of being in the courts. Again, especially for our clients that have been in municipal courts, they've seen lawyers, they've seen these judges, and really are just skeptical that anyone is there to really help them in a way. You know, that can make a bit of a rub for us with the ethics rules, having to navigate all of these different things. It requires us to be really flexible. I think one thing I frequently think about is the ethics meet in the road, where we literally have to go to our clients frequently. That's not just making a home visit. For us, that could be going to the jails, going to the underpasses where an unhoused family is living in a tent, making alternate accommodations to communicate, whether that's through letters or emails or standing phone calls. We really just have to have a lot of flexibility in our practice, generally due to our clients. And it's because we don't want to take away our clients' agency to be involved in their cases. We treat them just as we would treat a $1 million client, right? Just because they're unhoused doesn't mean they should get any less zealous representation. And we do everything we can to include them in the representation and give them agency over what is happening. And then finally, to wrap it up, how can you connect to our work? Well, of course, there is this lovely ethics rule from the Missouri Supreme Court that says that lawyers are actually supposed to engage in public interest work the way that we do. We have a responsibility as members of the bar to either engage in this work or financially support it. And so I at least wanted to give some information about how you can connect with us. We do have volunteer attorneys that work with us from anything from expungement cases to my housing cases to helping us, down in the road on civil rights cases. You can go to our website there. If you are interested in financially supporting our organization, we do primarily run on donations at this point. So you can donate through our website, share awareness of our work, follow us on our social media accounts and just kind of share out what we're working on and what we're doing. And then for our younger legal community, or even those not in the community, we have a Young Friends of Arch City group that is kind of in an infant stage, but we hope to grow that into a robust kind of organization for networking and being connected with our work. And that is what we have for you today. Here's our contact info. I'm happy to drop my personal email and phone in the chat, and we'll do that now since we're at time. And I'm happy to stick around for a couple minutes if you have any questions. But thank you to USA&M, of course, for letting us present today.
Lee and Jack, thank you very much for sharing your important work and creating a level of justice for those who are lacking in our community. It's important work, and one of the things I did notice, there are probably a handful of slides that did not print properly in the material that we distributed. So we'll get a complete set of the PowerPoint slides that Jack used today and Lee, and then we will distribute that. Kelly will send an email follow up in the next a few days with that information.
Thanks, Robin. That's my fault for getting those late to Lee.
No, not a problem. And Kelly does send out a separate electronic evaluation form to everyone. And also those who are looking for Illinois credit, she'll send out information to you all as well electronically. One question that Ken Chackas had for referrals, do you prefer just have the potential client call, or should we call one of your lawyers?
Either way is fine. To apply for our services, there is a link on our website, archcitydefenders.org. That would be just fine, or you can reach out to us individually. Generally, when that happens with me, I'll have my paralegal contact them and start the application, or I'll connect with the applicant directly. Either way, again, we're an open funnel. If you know people that need our services, just get them to us and we will be flexible to work with them.
Great. Folks, thanks to our friends at Arch City, Lee and Jack, and all the other lawyers who do just yeoman's work there. We're going to take just a few minutes, excuse me, and start at 11. Thanks. In the home stretch. Cardina, are you with us?
I am. Thanks so
Great.
much.
Okay, so I have shared my screen to your program, and we'll advance that for you, and you can just say next slide.
Okay.
Great. Ladies and gentlemen, we're in our last program, an ethics, an important ethics part, dealing with diversity, inclusion. It's been now, what, 3 years since the Supreme Court of Missouri added the requirement for our ethics CLE hours to this important topic. Cardina Johnson, who is one of the new mediators here at USA&M, serving as Associate General Counsel, Illinois Education Association, has put this program together for us. It'll be a full hour in Illinois and 1.2 hours of credit for Missouri. One other thing, those who are either on the phone with just a phone number or just a first name, Kelly is going to do a message to you individually in the chat. We need to know who you are so that you can get the appropriate CLE credit. If you are unable, because of the device you're on, to share that information with Kelly, you can reply to her by email, and she'll be emailing everyone who had registered. And her email is kspiller, SPILLER @USAM.com. Last administrative matter, just a reminder, our full day program, June 22, it'll have at least 8 hours of CLE and at least 2 hours of ethics there. We look forward to seeing you, as I mentioned, certain various topics, arbitration, anchoring damages. Martha Brown, one of our mediators who is really the expert in elder law, will be doing an update on elder law for us. So a lot of great topics, and we look forward to seeing you at that program. And that was not the last thing. The last thing is the proceeds of these programs. It is really our pleasure to donate to a variety of nonprofits. We will add Arch City to that particular list, in addition to Legal Services of Eastern Missouri and Land of Lincoln Legal Services. We certainly appreciate the great work that they do, and your registration and support of our best practice series and these programs go to support those important groups. Cardina, take it away.
All right. Thank you so much, Rob. Welcome. I know that sitting virtually, listening to a presentation can be challenging at times, so I'll try my best to bring some energy since I know I'm likely competing with your lunchtime. So hello again, I'm Cardina Johnson, and I'm looking forward to talking to you today about embracing diversity. It truly is a foundation to a better practice. I think first we will cover what diversity is with its two dimensions and overall benefits. Then we can discuss the generational and global differences, including ethnocentrism. We will also consider personal, cultural, and implicit bias. And then the second portion of the presentation will explore how marketing can expand our business from a multicultural perspective. So let's go ahead and get started. Next, please. So what comes to mind when you hear the acronym EEOC? Well, of course, we attorneys know that it stands for the Equal Employment Opportunity Commission, which is, of course, for enforcing federal laws and enforcing things that might make things illegal, like discrimination against a job applicant or an employee. But perhaps some of you may recognize who practice corporate or defense law, that from a compliance standpoint, you may ask your clients, hey, are you in compliance with the notices and filings for their particular employees? But today, I'd like for you to think, why do we have the EEOC and the laws it enforces, like FMLA, ADA, and Title VII? Who is being protected and why? Next. I encourage us to celebrate why we have these laws in the first place. Essentially, the EEOC is a step towards enforcement of our differences in America. So consider this list that's on your screen and how it creates a narrative as to how different we all are. And these are some of the factors that make us, unique individuals. Next, please. To me, diversity means to consider all people as unique and just recognize, understand, and appreciate their individual differences. In the US, diversity is often associated with race and ethnicity, but we are diverse in a wide variety of ways, and we have multi-dimensional layers of diversity. Diversity dimensions can be split, when you think about it, into two tiers. So there's a primary dimension and then a secondary dimension. So when you think of a primary dimension, think of those qualities of self that cannot be changed, such as your race or your ethnicity or your age. But your secondary dimensions include those aspects of self that are more fluid and where some personal choice is involved, like, your marital status. You can decide who you're going to marry. Of course, educational background, your religious affinity, and your occupation. Those are just some examples. Embracing diversity means accept, without judgment, all aspects of an individual on both a primary and secondary dimension. So there are so many different perspectives and talents we collectively bring to the table. I just think the takeaway when it comes to diversity is to think of diversity in a very broad way. When you think of diversity, not just based on race. So as we tend to focus on in America. Next slide, please. So what are the benefits to embracing diversity? Why change? If it doesn't feel broken, why try to fix it is kind of the thought. Next slide. Well, on a workplace level, it will result in a variety of different perspectives. This in turn will certainly yield faster problem solving, higher innovation, and increased creativity. As a whole, the group will be at better, at decision making. And because of the high level of success, the employees will be more engaged and less likely to leave, and therefore hiring is even improved. These things will lead to a better company reputation and increased profits. Now, rather than use a workplace example, because again, I know I'm standing between your lunch, I think I'm going to use the trivia nights because that's something that my husband and I really enjoy. We're big fans of trivia nights. And we come and we try to win. right? So they tend to support a good cause, and they're a lot of fun too. So of course, that's a draw. I do notice that there is a significant correlation between us doing well at the trivia night and us having a diverse team. And this is not really surprising when you think about it. Consider like who would know the answers to the following questions. What year did the TV show Little House on the Prairie first air? Well, consider who would be more likely to know this answer is 1974. Maybe someone who was school aged or older in the 1960s. What is the name of the rapper Lil Baby's debut album? Who might have a tendency to know that answer is Harder Than Ever. A person who is a big fan of rap music, a younger person, or at least one who follows current pop culture. What year was the first World Series played? Who might tend to know that answer is 1903. A sports enthusiast, a big baseball fan, someone from Boston where it was played. The point is, if you have all different kinds of people on your team, the more likely it is that the group will be successful. A diverse group will use their diverse perspectives towards the faster problem solving. When the group is doing well, the more likely there's participation and people are engaged. They get bragging rights. You become the one to beat at the trivia, and the reputation is heightened. And obviously the profits are good because you might just get cash at the end for winning. So I think you understand the point is, it's a common goal when folks are working together, and a variety of different perspectives can have a significantly more positive, impact than a less varied group. Next slide, please. So another benefit to embracing diversity is it aligns with the fundamental principles and values that America was based upon. For example, in a democracy, collectively, every voice should be heard. In our Pledge of Allegiance, we attest that we are, quote, one nation and indivisible, and that there should be liberty and justice for all. We can also consider the iconic phrase, all men are created equal, which goes on to declare that we can have certain unalienable rights like life, liberty, and the pursuit of happiness. We should, finally all recognize that embracing and being a champion for diversity is just simply as American as apple pie. On a personal level, you may want to think that it's just the right thing to do. Embracing diversity adds so much richness to our lives, making personal and professional endeavors much more interesting. Cultural differences should not separate us from each other, but allow us to, evolve and grow together. Next slide, please. Another benefit to diversity can be seen through values and interactions with individuals from different generations. So, I want to make this clear. While no generalized or generalization of any particular group is going to apply to each individual, there is a commonality that individuals growing up in a certain era experience together that tends to shape them. So for each generation, there were formative events that, people have experienced collectively at a time when they were approaching adulthood. So when you think about the silent generation, they were born approximately between 1925 and 1945. They grew up with the world wars, the Great Depression, the GI Bill, the birth of TV, and the rise of suburbia. Then when you think about the baby boomers, born approximately from 1946 to 1964, depending on the resource you look at, they were responsible for the hippies. They saw the JFK assassination. They were aware of the Vietnam War and the Cold War, and started the civil rights movement. Generation X, born from about 1965 to 1979, saw hyperinflation and economic turbulence, the fall of the Berlin Wall and the Soviet Union, troubles in the Middle East, and a significant decline in what we have known as the nuclear family. So the millennials who were born from about 1980 to 1985 saw the dawn of the internet. 9/11, Hurricane Katrina, the emergence of just mobile technology in general and social media. Then their youngest generation entering the workforce are the Generation Zs, and they currently are aged about 24 or 25 now or younger. And some of the things that affected them potentially are the election and re-election of Barack Obama, widespread internet and mobile usage, and the legality of same-sex marriage. So for these 5 generations, you can expect that the times in which they came of age may give us clues as to what their beliefs and values may be. Recently, I was participating in an attorney staff meeting where a Latinx millennial was explaining to a white baby boomer some nuances about a case involving racial discrimination and an exchange of words on Snapchat. Not only could the millennial provide a valuable insight on how Snapchat worked, having come from a technology generation, but he also ended up explaining why a particular Latinx slur was offensive. So, that discussion that they had, that prompted me to learn a little bit more about Latinos and Hispanics and the correct terminologies to use, because I wasn't sure. And I think what I learned, and you'll have to fact check, is that Hispanic and Latino are often used interchangeably, but they are actually defined differently. The Hispanic refers to people of Spanish-speaking origins, and Latino, Latina, and Latinx, the gender-neutral version of it, refer to people whose origins are geographically located in Latin America. So based on these 2 defining criteria, the 2020 US Census used both terms, and an individual can identify as either one or the other. So I also learned that many Hispanic Americans consider themselves white, and many from the Caribbean consider themselves Black. So one thing is certain, there is a lot of intersectionality and ambiguity surrounding Latinx and Hispanic identity. And I'm glad that my millennial coworker, while trying to educate my baby boomer coworker, prompted me, a Generation Xer, to become more educated about Latinx Hispanic culture. That is just one of the many examples of how the benefits of diversity can enrich a work environment. Next, please. So let's move away from that and look at the perspectives of the US. To look away from the perspectives of the US and look forward towards the global views. Next slide. Let's consider ethnocentrism. It is a belief that the culture you grew up in is superior to all other global cultures. Because most of us have an intimate connection with where and how we grew up. Most of us have a sense of pride in our culture. And it's understandable then that we think of our culture as the best or the greatest. And I think that's completely normal, and that's okay. I think the problem arises when we use our social and cultural background as a standard to judge everyone else. And that is, we start thinking less of anyone who's not part of our immediate culture. It's not just a problem in the United States, though. We're talking citizens of all countries and all cultures are prone to ethnocentric beliefs. An obvious example would be, how people in one nation view the culture of other nations. An American citizen, for example, might feel that their culture is better than the cultures of France, better than China, better than Brazil. And along the same lines, a Chinese citizen might feel that their culture is superior, to France, Brazil, US. It's just the way that it works out. So ask yourself whether ethnocentrism might be an issue for you. And since we're not in person, I can't ask you, I'll just share my view and my experience. And I really was not around a lot of people who were not native English speakers when I was growing up. So as a teen, when I entered the workforce, I began to encounter people where English was like their second or even third or fourth languages. And some grammatical, mistakes were made while they were speaking English as a result. And so I immediately made the assumption that they were not well educated. And looking back, I realized I associated, less than stellar English with being poorly educated in the US in general. Then I started to realize that I should not make that assumption about people not born in the US, especially considering the people I encountered, they knew at least 2 languages and I only spoke 1. So ask yourself, do you have your own example of an ethnocentric view? And will you work to change your internal dialogue? Next one. So, perhaps, ethnocentrism exists because all cultures, have certain norms of interacting. And likely, they believe that the way that they do things is the best way. These norms fall on a spectrum of what we call high to low context. So the concept of high and low context cultures offers a good way to think about culture norms and interacting from a generalized perspective without a stereotyping about a group. So similar to the way that we just considered how the generations were born may be affected by something, this is just sort of a generalization that should not be obviously applied to everyone. So the concepts of high context and low context refer to how people communicate in different cultures. Differences between the 2 approaches can be seen by focusing in on the manner or style in which communication is conveyed. So the context of the communication will reveal whether the attitudes and true meanings are, displayed mostly through actual words used by individuals, or whether meaning is mostly implied from the context or nonverbal cues. High context cultures tend to transmit a lot of unspoken information that is implicitly transferred through nonverbal cues. People in a high context culture, like Saudi Arabia, tend to place a larger importance on long-term relationships and loyalty, and have fewer rules and structure implemented when they interact. But low context cultures tend to transmit a lot of information that is explicitly expressed through the message itself, and rarely is anything, implicit or hidden. People in low context cultures, such as the UK, tend to have short-term relationships, follow rules and standards closely, and are generally very task-oriented. Understanding whether your international clients are high context or low context will help you adapt your communication style and build stronger relationships with them. So what are some, next slide, please. So what are some examples of generalized, characteristics of high context cultures? Again, they won't apply to everyone in the group, but you will find a tendency for those in these cultures to communicate indirectly, to take a slower pace with things like time. The communication is layered, nuanced, and very subtle. So what are some cultures that you might think are high context? Well, Asia, Middle East, Latin America, and Eastern and South Europe, so Southern Europe really, are considered high context cultures. Next slide, please. Low context cultures, on the other hand, tend to be more concise and straightforward, and the communication is direct and clear. What are some examples of low context cultures? Well, Canada, Western and Northern Europe, Australia, and no surprise, the United States. Next slide. So we've discussed what diversity is with its 2 dimensions and overall benefits. Additionally, we've discussed generational and global differences, including ethnocentrism. Now it's time to go a little bit deeper and discuss bias. On the road to embrace diversity, there will inevitably be an encounter with bias. A culture can have its own bias, and individuals with a culture can have their own personal bias. So a cultural bias is a tendency to interpret a word or action according to culturally derived meaning assigned to it. So for example, some cultures view smiles as a deeply personal sign of happiness that is only shared with people that they know. Others view smiles as an indication of general friendliness to be shared with all. So a personal bias, on the other hand, is a tendency to interpret a word or action in terms of personal significance assigned to it. Personal bias can derive from culturally defined interpretations, but also can originate from other sources grounded in personal experience. The individual internalizes the cultural attitudes until he or she believes them to be entirely personal. I guess put another way, a personal bias is an individual's feeling about a particular person, or that person shapes the individual's interpretation of it just by having the experience. So the bias can lead to more favorable or less favorable judgments that are fueled by the bias. And I think that's kind of confusing. So I'd like to want to make sure I throw in an example of these concepts. So in general, I think there is starting to be a mounting countercultural culture. I think the US traditionally has had a culture that embraces guns and hunting. This, of course, is rooted in the constitutional freedom that we all have the right to bear arms. Nevertheless, someone raised in a rural setting might have a different relationship to nature and hunting than someone raised in an urban environment. Someone raised in the suburbs, for example, might have a slightly different mindset than both rural and urban dwellers. So for me personally, for many years, I had a personal bias against hunting until I worked with, got to know, and became very, very fond of my former secretary. She is from a rural, very small area. It's even called a village. She absolutely loves hunting. It represents family and friends and fun. Her kids and husband are, avid hunters. They're always doing some kind of activity. She explained that hunting represents special times with her. Her father has since been deceased now. And she thinks of him fondly and all the things that they did from a tradition standpoint and the respect for nature. And she was also taught to always eat what you killed. She kept a picture of her son and a shot deer with his gun proudly displayed on her desk every day. And as a matter of fact, there's a phrase that she used. It was called, "That dog don't hunt." And that was a phrase that she would often use to mean that an idea or concept would not work. So she also told me that the good Lord made animals to eat. So she clearly has a cultural and personal bias towards guns and hunting. I, on the other hand, grew up as an urban dweller, and I never in life, literally, had met anyone who I was aware of who hunted as I was growing up. So the absolute only real life experience I had ever had with hunting was when I saw the Disney movie Bambi at about age 7 or so. The scene where Bambi's mom was shot by a hunter, it absolutely shocked me and horrified me. I mean, why in the world would anyone think hunting is okay? That was my mindset. So by getting to know and becoming fond of my former secretary, however, I was able to recognize my personal bias and to move away from that view. Now, I'm not saying you're going to find me out hunting, but I'm very proud to say I no longer judge hunters as being, quote, bad people. As for cultural and personal biases, again, against hunters, my former secretary would say, "That dog don't hunt anymore." So I'm proud of her for that, for helping me get better. Next slide. Thanks. So biases can be based on so many factors. Let's consider the answers to these questions. Who's in your network when you think about it? And with the first question, I'm thinking, I am a Black American woman. What are you thinking as you describe yourself and as you move forward through it? Do you see a theme or pattern when you answer questions about yourself? Next slide, please. Okay, with the next slide. It's not moving. Let's see. Are we having technical difficulties?
Is that
There we
the
go.
next?
Perfect. Thank
Good.
you.
Okay.
And so what you may have found is that there is a level of homogeny in your interactions. And if that's the case, we may not experience high levels of cross-cultural or diverse interactions in our everyday living. The next slide, please. Our conscious biases are easier to identify, and we can often articulate how they were formed. Through open-mindedness and having diverse interactions on primary and secondary dimensions, biases can change, as was in the case with me, for example, with hunting. I literally did change. I just wasn't aware. I didn't know anyone. Next slide, please. Implicit bias, however, is totally different because it's subconscious. Just as like music is thought to communicate subliminal messages over time, the culture that one lives in passes along messages to those living in a given society, and they're just not even aware of it sometimes. So those that pick up on the messages should not be labeled as bad people. I mean, we're all living in the society and we will pick up on the messages being delivered. It is what it is. Next page. So where implicit bias can be a dangerous concept is when a barrier or roadblock is created that we are not aware of, and we're not consciously thinking that that's where our mindset is. So the first step to check for this is self-discovery, which will entail spending some time exploring one's own ideas and beliefs. There are implicit bias tests on the internet to take, like the Harvard Implicit Bias Association test. But first, you must be open-minded and have a willingness to dive deep within. So with that said, I want to show a 3-minute clip of Dr. Robin DiAngelo. She received her PhD in multicultural education from the University of Washington in Seattle. And her area of research is in whiteness studies. And I'd not heard that study before. And critical discourse analysis, tracing how whiteness is reproduced in everyday narratives. She coined the term white fragility in an academic article in 2011, which means the discomfort and defensiveness on the part of a white person when confronted by information about racial inequality and injustice. So this excerpt is from a concept from her book called White Fragility, Why It's So Hard for White People to Talk About Racism.
Many people can recognize the explicit kind of conscious dislike type of racism, racist jokes, racist expressions, the KKK. But I want to help white people see the everyday racism that's embedded and that we participate in. And I want to look at neighborhood and school segregation as an example. I'm going to start with this app here. These are the app's founders. It's a new app called The Sketch Factor. And what it does is when you go to a new city, you can put in where you are and it tells you which neighborhoods to avoid because they're sketchy. And of course, sketchy is very much associated with race and class in the white mind. And so now we have the convenience of segregation through an app. We don't actually have to talk to other white people about, where are the good neighborhoods and the bad neighborhoods. And that good neighborhood, bad neighborhood, good schools, bad schools discourse is an example of new racism. I don't think it gets by anybody that is racially coded language. So this way we can come out and police those racial boundaries without ever kind of naming race. But we all know what we're talking about. And I think the most profound way that my life has been shaped by my race is through the power of segregation. Most white people do live in segregation. We choose that segregation. And in a lot of ways, we celebrate it. what makes a school good and what makes a neighborhood good? Well, the absence of people of color. That is the way that white people measure the value of their neighborhoods and schools. And while we don't come out and name that, we all know what it is. And so I have had to think very deeply on what it means to have grown up in a primarily white neighborhood, to be born into, to go to school, to study, to learn, to play, to worship, to love, to work, and to die in segregation, and not have one single person who loved, mentored, or guided me convey that there was any loss. And I'm going to repeat that because I think it's very profound and I really want to sit with it. That I could live my whole life in segregation. In fact, if I follow the trajectory that my loving parents laid out for me in my good neighborhood and my good school and my good college and my good career in which I would ideally rise to the top, I could easily never have any consistent, ongoing, authentic relationships with people of color. And not one person who guided me ever conveyed that there was loss. Just sit with that for a moment, that there is no inherent value in the perspectives or experiences of people of color. If my parents, if my schools, if my curriculum, if my teachers, if my government saw value in those perspectives, I would be given those perspectives, but I wasn't given those perspectives. And that shapes my relationships. It shapes what I care about. It shapes what I see, what I don't see, who I build my life with and who I don't build my life with. And that is the level where we really need to look at race inside of us and with us.
Thank you for playing that. And let's go to the next slide. So starting on the path of exploring your own biases is an important, I think, life-changing endeavor. It is easy to engage with the people that we know and share, inside jokes or history with them that doesn't resonate with everyone. But when this occurs, the people that aren't in the quote in group on the joke or the inside joke will feel isolated and left out. It will very much be difficult to sort of make them feel included. So if we are all in a dominant identity group, let's just say, preference for our in-group can have the same impact as hostility towards the out-group. So as the US continues to open up post-pandemic, I have a challenge for you. Next slide. The next time you have the opportunity to seek out a connection with someone or a group outside of your comfort zone or norm, I dare you to just step out of your comfort zone and go. Whether it be at cultural events like a festival or a religious event, a music performance for types of music that you wouldn't necessarily ever listen to, so long as it is something that you would not normally be involved with. So that's just my little ask. Next slide, please. Okay, so how about we switch gears all together on the topic and turn to the topic of how to expand your business through inclusive multicultural marketing. Successful inclusive businesses understand that embracing diversity is important to their success. Legal professionals who understand and embrace diversity and cultures of all types reap personal and professional benefits. So in this section, what I want to cover is a review of the buying power in local markets and advertising and social media and how that can help expand business. Thirdly, local demographics and trends. And next, I'd like to talk about the power of networking and community outreach. And also, it's important to have a specific inclusive business plan that's centered around diversity and inclusion. And then finally, how can we all embrace equity, and inclusion in our practice. Next slide, please. So multicultural marketing growth varies by state and local area, of course, but according to the 2017 Multicultural Economic Report produced by the Selig Center at the University of Georgia, the buying power of minorities will continue to grow at rapid rates through 2022. The total share of US buying power controlled by Hispanic consumers was 10.3% in 2017. And this year, the number is expected to rise to 11.1% in 2016. African-American buying power was roughly 1.2 trillion and could grow to 1.5 trillion by this year. And then, representing about 6% of the US population, Asian Americans' buying power stands at about 986 billion. So the point is that there's a lot of power and money out there. So without a doubt, a portion of these funds will be spent on legal services. You have more than $3.9 trillion out there. So let's go to the next slide. So when we're creating, advertising and social media marketing, we of course want to be compliant with state and federal laws. But the internet is how a lot of attorneys are found. Commonly encountered forms of lawyer advertising include, of course, television, radio. There's some print ads, billboards, direct mail, marketing, law firm websites, and participation in telephone directories, commercial directories. And, there's just a lot of advertisement that can go on. And according to an ABA survey, legal advertising has surpassed 1 billion. 80% of respondents say their firms maintain a presence on social media, and which is the highest since 2016. And among those firms that do use social media, LinkedIn is still the leading platform at about 79%, followed by Facebook at 54%, but the use of Facebook is declining. But anyway, consider if you do have advertising as part of your strategy, how you do it, and will it have a multicultural appeal? Next slide. When you think about multicultural appeal and you look at this slide, this particular ad, let's consider understanding the value of analyzing the demographics of your community and creating an inclusive brand. What does this law firm ad say or not say to prospective clients? What can be done to change the message being sent? Is there a female attorney or other legal professional who could have been added to this photo? After all, females do make up 55% of the United States population. Next slide. And then when we're talking about researching, local demographic trends, that can be helpful in expanding your business as well. Understanding and interpreting local demographic data is critical. If, for example, you have a large Hispanic or Latinx or Asian population in your community, find out, their specific country of origin, are they Chinese, are they Cuban? And for areas of practice like wills and trusts, examine their age segments and median household incomes to develop a sound marketing plan. The analysis of local demographic data will help you develop marketing strategies and business plans that address the specific needs of a diverse market area. It gathered the data in areas, such as a total population, and, you could also look into the population by nationality or race, income, and employment. The American Immigration Council's Immigration Policy Center and the Migration Policy Institute are great resources. The goal for using this research, of course, is not to only market to one particular group, but just to be aware. By using metrics, law firms, and other legal employers, you can access multicultural business outcomes more effectively. So You may learn that in Missouri, which I found it interesting, that there are about 70,000 Mormons, and that number has tripled over the last 2 decades. Additionally, the last 2 decades have seen remarkable demographic change in Tennessee. So for those of you who may have some global and national appeal, Tennessee has one of the fastest growing immigration populations in the country. Although immigrants still make up less than 5% of the state's total population, there's still about 340,000 people with the current rates that are there, and that represents business opportunities. And according to the American Immigration Council, of the 340,000 people, about 100,000 of them are from Mexico. So that's something to think about. Next slide. Then, of course, there's always the importance of networking and performing meaningful multicultural outreach in your community. And that cannot be overemphasized. There are many ways to initiate, build, and maintain relationships through networking with the ultimate goal of generating referrals and attracting perspectives. Networking by using social media is a critical part of any networking strategy, I would think. But for this slide, let's focus on face-to-face networking, which is really an invaluable way to connect. Face-to-face networking is especially important when trying to create an inclusive brand, because at the end of the day, trust is established through genuine, authentic person-to-person contact. So pushing away from your desk and computer to interact, on a one-on-one basis is a must at some point when the world is sufficiently open to your comfort level. Multicultural community outreach, which is a grassroots effort, is an outfit that reaches out to the multicultural clients where they live and work. So this has been proven to be a successful way to make a meaningful connection with a diverse market and to expand business. The law can be a confusing and intimidating process for many. And so traditionally underserved communities are seeking attorneys that they can trust. Positive word of mouth within or across a diverse range of cultural groups can go a long way in gaining references and building trust with those relationships. In fact, studies have shown that influencers represent one of the best ways to connect with various typically underserved communities. Influencers include, immediate family, friends, and neighbors. They can also be found in places of worship like churches, synagogues, mosques, temples, non-denominational congregations. Then there's networking with medical professionals, teachers, and other attorneys, as well as the local community businesses. Effective legal professionals with an inclusive mindset typically seek to understand and develop their community network, as well as understand and reduce whatever prevents or inhibits their outreach. So consider the example of volunteering for like an Ask a Lawyer event. There may be, again, when I talked about teachers, there may be an opportunity to show what you do at a school and, Ask a Lawyer type event at a school, or an event that helps educate multicultural potential clients on the quote how-tos. That could be something that you could sponsor, provide useful and accurate information. And that can help establish strong credibility and build, relationships and equity over time. So consider these outreach methods to market to multicultural potential clients through professional specialty associations, because there are different minority groups. There are some lunch and learn events that you could have. You could collaborate or sponsor specialty minority bars, LGBTQ plus and other advocacy groups with their community outreach efforts. And there are just a lot of options. You can consider going to colleges and universities and selecting a intern or externship. There are often multicultural organizations on campus while school is in session, and that you can reach out to them as well. Then there's the local media. Consider, you could be a guest writer for a specific publication or blog, or make an appearance on a local Spanish, Asian, or African-American media outlet. And even if you don't even speak the language, you can get someone to translate it for you or interpret it for you. Your inner circle network is another aspect of your planning. And you can consider, who is in your sphere of influence and who do they know? Consider your family, friends, acquaintances, and people you come in contact with, but don't necessarily know. I'll consider all of those options. Next slide. Now let's consider how we formulate an inclusive business plan that embraces diversity and grows your business. Well, when you're developing an inclusive business plan, you probably can ask yourself 5 questions. 1, does your law firm have name recognition across communities within your market? Diverse communities is what I'm speaking of in particular. Does it have a resource that extends its outreach to all communities within your market? And another question you could ask is, how experienced and knowledgeable are you about the communities within your market? 4, do you have a strong list of contacts and connections to the various communities within your market? And 5, what is your current advertising strategy to appeal to all communities within your market? Assign each factor you can think of into either a strength or a weakness category and develop specific goals, and think of other questions to ask yourself that are tailored to the type of law you practice and your specific goals. So when developing your inclusive business plan, you can also ask yourself questions like, hey, are there particular communities within your market that are heating up or cooling down? Are there any barriers like language that will make legal representation easier? How diverse and inclusive is your workforce? What are the latest apps being used by your potential clients? And are there ways to leverage them? Are your competitors effectively appealing to all communities within your market? If so, how are they doing it? When you look at the analysis in total, you can begin to see ways to gain competitive advantages like external opportunities and internal strengths, as well as places where you might be at a disadvantage. Next slide. Ultimately, embracing diversity on both a business and personal level leads to achieving an optimal level of diversity, equity and inclusion. So in a business context, diversity, equity, and inclusion are often discussed all together, almost interchangeably, but they're really not the same. In big firms, management might attempt to hire a diverse range of people, but that doesn't necessarily mean that the diverse hires are made to feel comfortable and welcome in the firm itself. And that is the company that has to make an attempt to make the culture of the company more inclusive, as opposed to it's being the responsibility of the individual to, quote, fit in. That's a different way of thinking of it. Because again, it's about inclusion. So in such instances like that, new diverse hires often leave, the firm sooner rather than later, and the cycle begins all over again. Companies that do this are said to be, quote, checking diversity boxes. They're making a superficial attempt to say they are doing what's right, is what the allegation or criticism is sometimes. But because these efforts aren't authentic, people never truly feel welcome. And they never feel part of the culture or team and end up leaving as a result. So, of course, we know that's not your company. So what strategies can you use to ensure, though, that your legal practices are, in fact, inclusive? A business that practices equity and inclusion is one that truly tries to create a culture that makes everyone feel comfortable and welcome. Inclusive cultures, they compromise on big things. Well, they consider the big things, of course. They have the sexual harassment policies and the discrimination laws, et cetera. But they also look to the little things, acknowledging the holidays and important days of all religions, making online marketing material accessible to all, regardless of physical abilities or challenges. offering, contracts that are translated into multi languages. Just being an inclusive business is going over and beyond what you're mandated to do, and to do what you feel will make your clients, all of your clients, feel valued and respected as people. And that, that goes for your employees as well. It's a focused leadership approach that is intentional, a priority, and analyzed regularly. So for those who are solo practitioners, these are thoughts that you can consider as you grow and expand. And for those who want to remain solos, perhaps you can consider embracing equity and inclusion when you make the decision to hire support staff. Next slide. I think I was a slide behind. No, I wasn't. Okay. So in short, successful businesses understand that embracing diversity is important to their success, because first, you look at your local demographics and trends and confirm that diverse multicultural populations exist in the local markets, and you're well informed. Then you study the buying power of the local markets, and you identify prospective clients. Third, legal professionals who understand and embrace diverse cultures reap personal and professional benefits. And lastly, by using metrics, law firms and other legal employers can access multicultural business outcomes more effectively. So at this point, I have concluded my presentation, and I see that we have about 5 more minutes left. And I wondered, Rob, if we have any questions, you can advance to the next slide.
There's one after that.
Okay.
I think that's the last one.
So do we have questions?
Cardina, I did not see that we had.
Well, I was prepared for that. In the event that we did not have questions, I can share with you just a little bit about what are some business norms and etiquette when it comes to interacting with multicultural clients. So the first one is you can always obviously talk less and listen more. And I know it sounds like a simple thought, but really, you really do want to really get to know your clients, especially if you're considering the high or low context communication that we discussed earlier. Another thing that you can consider is you can be sure to use the correct names and titles. Please don't assume and ask instead. You'll be surprised how many people are offended by the use of the first name, how many people are offended by, not being called Miss or Mr., depending on who they are and how they've grown up. I can tell you that as an African-American woman, I have a lot of contact with elderly African-American women from the South, and they are especially offended, I find, if you just call them, "Hi, Sally." They really don't like that in general. That's been my experience. So that's just an example. And then the third is also show deference to the elderly, because, a lot of the times different people embrace elderly differently, in the sense that some are highly valued in some cultures. And so you want to make sure that you're giving that deference and that respect. Another thing that you can do is learn at least a few phrases in the client's native language. I think that would be super impressive, and to show that you've gone that extra mile and that you have some knowledge. Just a simple hello or a goodbye, that might be something to consider. A fifth thing to consider is, be extra careful to show respect. because the concept that one's sense of status and worth can be important to some. People are very different. For example, I did come across a African man who really has a sense of worth in his family lineage. And so he would say that he came from kings and this and that. And that was super important to him. And he really wanted that extra respect. 6, don't try to create an instant friendship. You know, it takes time sometimes to get to know someone. So you really want to build trust. And if you come across too strong, too fast, it may be too much. Number 7 is to cultivate empathy. Put yourself in others' shoes and just think about their situation. I think connecting with someone in an empathetic way, that goes a long way, especially even for us mediators. Number 8, don't try to make jokes. You know, I think in general, humor doesn't always translate cross-culturally as well as we think it does sometimes. And so we just want to be careful about that. And then a 9th thing to consider is to show respect for others' customs and their culture. And finally, acknowledge mistakes and apologies when appropriate.
Fabulous. Cardina, thank you. The word that comes to mind on your presentation is excellent. And I am going to predict that many who are attending today will go to our YouTube channel. We'll have this posted probably by Monday, and we'll take a look and feel that it's worth looking at this segment again as a terrific reminder of things to help us in our practice, to help us in our lives outside of the practice. What a wonderful thing for us to consider as we go forward. It is interesting to me that just a couple of years ago, the American Bar Association passed a resolution at their annual meeting, and it called for ADR providers to add and have a more diverse panel. It was interesting to me because our organization at USA&M have been doing this for not just years, but decades. But it also called on practicing lawyers, on the other hand, to use firms and to use neutrals, arbitrators, mediators from a diverse background. And it was an important resolution on a national stage, and it's something I just wanted to remind folks of because it is so important, adding to the richness and the comfort of those in the room who are needing their case resolved by mediation, as an example. So Cardina, thank you. I want to thank all of our speakers, Jack and Lee, the judges, and Bud. Terrific program. Folks, I have to tell you, this is the first program we have done where we had more than 90 people for all 3 hours, and it's a testament to our speakers and the topics. We thank all of you for participating and allowing us through your fee to be able to support the important organizations, Legal Services, Arch City, Land of Lincoln, and many others. We look forward to seeing all of you June 22 for our full day program. We hope you all have a great afternoon and a wonderful weekend. Be well.
Thank you.